Today I'm going to talk about health initiatives, the Health Initiatives Department, HIPAA policies and procedures. All programs in health initiatives must comply with HIPAA. So that includes all of the different departments within the Health Initiatives Department. ICANN, now that we're so many, we all do have to comply with HIPAA. We have to comply with the Department of Health and Human Services regulations around HIPAA and the HITECH Act. So these policies and procedures that have been drafted are intended to protect the security of protected health information and electronic protected health information, and to protect the integrity and confidentiality of that information pertaining to our clients, and also to provide guidance to you all and the volunteers, which I gave a piece of this training this week, on how to comply with HIPAA in a way that's practical in relation to the work we do. This is just a general outline of the presentation, so I'm going to give a few introductions and general definitions, talk about the minimum necessary standards, our data and information access policies, the risk analysis and evaluation policy, and then a bunch of different policies specific to destruction of physical documents and electronic documents, social media, physical transportation of protected health information, work at home, fax and email, things like that. You'll see throughout this presentation there's a reference to the privacy officer. I used to be the privacy officer for the whole department, and then we blew up, and it became, I don't think it's a good idea for me to be the privacy officer for every different program in health initiatives because of how different the programs work. So the manager of each of the programs will be designated as the privacy officer, and we decided that our last risk analysis with the HIPAA consultant. So, for example, Juan, you will be the East Harlem privacy officer. Kristen, you will be the Helpline privacy officer. There'll be a privacy officer for CNN, for DAB, that sort of thing. So when we reference privacy officer in this presentation, normally it's about getting approval to do something from your privacy officer. It's usually the law. Okay. So individually identifiable health information is sensitive and confidential and protected from improper use and disclosure by HIPAA. It creates certain rights of access to information for our clients and other parties. Loss, breach of confidentiality, or inadvertent disclosure of this data may cause severe harm to the subject of the information, to our department, and to employees. As a consequence, we're charged with ensuring access to this data is limited to minimize the risk of unauthorized disclosure. HIPAA specifies that only those individuals with a need to access and use individually identifiable health information should have access to that information. Limiting access to a need-to-know basis and giving no more access than necessary to perform duties within health initiatives helps us comply with HIPAA. So all of these policies and procedures are kind of generally couched in this minimum necessary standard. Everybody should only really have access to the minimum they need to perform their job. Sometimes, like on the helpline, for instance, that is a heck of a lot of stuff, even though it's falls within the minimum necessary standard, because we have to, for example, go back and find clients who have called before, make sure we don't have duplicative entries, be able to go back and see what we've helped the client with before and access their records. So that's one example. So here's some definitions on individually identifiable health information. It includes clinical, financial, demographic, and lifestyle information collected from or about an individual. And these definitions are protected health information, electronic protected health information, the privacy officer, which I talked about, and also throughout this presentation, and in the policies and procedures themselves, that's why I use it here, the policies and procedures reference workforce, which is staff, volunteers, students, trainees, and anyone who's kind of extern, anyone who's working for health initiatives, regardless of whether or not they're being paid. I tried to push back on this workforce theme, and I was told, no, it absolutely has to be this broad. And so, the use of workforce and staff are kind of interchangeable in the presentation, but it means anyone who's accessing the information. So some examples of protected health information are here are a list of some identifiers, not exhaustive, names, geographical subdivisions smaller than a state, elements of data pertaining directly to an individual, so birth date, admission date, discharge date of death, phone numbers and fax numbers, email addresses, social security numbers, certainly, medical records, health plans, beneficiary numbers, account numbers, addresses, things like that are all protected health information.
Account numbers refer to what is the
I would think in this context, like a medical billing account numbers.
Do you know what it is about ages 89 and over? There's like a
Date of death in all ages 89.
I think it's because there's just not that many people. My guess is that there's not that many people over 89, right? So it's a smaller group of people. If that's what it is, that they're more easily identified because it's a small population.
Right. It's possible they really have
more vulnerable population.
I don't know that in this context that matters.
Account
Likely what you're saying.
account number would include like a case number, like we email each other and we don't include any names, but we do include like a case number so that we can reference.
What case number? Client ID, you say?
Yeah.
Is that be?
No, I don't. I wouldn't think that our internal numbers would, but like an insurance company's internal numbers would.
Okay.
But I can double check that. I'd like to try to follow up on any questions with counsel downstairs who's directly in touch with the HIPAA consultant and has done a lot of HIPAA work in her career. So if there are any questions, do ask them. I know that this is like, it's hard to get excited about this, but okay. So our client ID, right? Okay. So one of the policies that was put together to help us comply with HIPAA is the access a group of access policies. And the access policies are around determinations of who gets access to what data, how that access is established, how it's modified, how it's terminated if it needs to be. So I'm going to go through this quickly. I talk again about this minimum necessary standard. The gist of these slides are that there are people in IT and your supervisors who are looking at what you need to be able to access in terms of databases and on the shared drive in order to perform your job functions without getting access to too much information. And we're recently started working on revising the access that people have. And you'll see soon that your access is probably going to be completely restricted and then opened again to new access. Basically the gist of it is that we must make all reasonable efforts to ensure not to use or disclose more than the minimum amount of PHI necessary to accomplish the intended purpose of the use or disclosure of a specific case. So the supervisors and the IT directors have to identify those who have a need to access information to carry out their duties, the categories of access they need, and to make efforts to limit access to others. So, for example, an intern might not have the same access as a case handler. A case handling intern might have more access than a case planning or a policy intern would have because they would be dealing with clients. So the gist of it is just that you know that someone's behind these decisions and that they can be modified and should be modified and changed. And that if you access more information than you're supposed to, it could result in you having to look at the sanction, or HR looking at the HIPAA sanction policies in regards to your actions. So we talked a little bit about the minimum necessary rule. No one's health initiatives may use, disclose, or request the entire medical record except in the case in which the entire medical record is justified as to the amount that is reasonably necessary to accomplish the purpose of equal disclosure. Often we need that in terms of HIPAA. When we're writing an appeal, we want every medical document that has anything to do with the specific service the person is seeking or services that are related because they help both parties. But in a case where the entire medical record is not warranted, you would be requesting that information and you would be granting access. And then there's some here listed grounds here for not giving access to workforce members. So, you know, if you refuse to sign the HIPAA compliance policies, or if HR is on notice of you as a HIPAA risk, for example. And these are obviously extreme examples, but something that's in there that you should know. So once you're authorized to have specific access, there's a password policy. You have to use a password of 9 characters or more that cannot consist of your name, spouse's name, parent's name spelled backwards or followed by a single digit. There's a whole slide on the password policy, and that's, of course, to ensure that people are not copying it, don't test it, and can't get access to others' information. So data users can only use data they have access to for purposes authorized by the department and must comply with policies and procedures governing protected health information and may not disclose the data unless authorized by a client. So you basically, this is a theme throughout all these different policies, including the fax policy and the email policy and the mobile device policy. It's not for personal use. You can't access the data for personal use, no solicitation, no campaign fundraising, no religious activity, all those sorts of things. And, you know, this all sounds really far-fetched, but we have had instances where we've said, you know, we want to make sure because of the background of someone, we've said, okay, is this safe or does this pose a risk? And so it's an important thing to be thinking about. Workforce members working directly with client information should only have access to the health information concerning clients they've been assigned to unless there's some sort of inquiry or emergency that they need to respond to, and that is normally granted by the supervisor unless it's in the normal course of business. So if you're on the helpline and you have someone calling, you of course search all of the database records to see if it's a return client to make sure we're not duplicating efforts or entries, and that we have access to all of the information that's relevant to giving legal advice. But you're not just accessing random client IDs because you feel like hearing someone's story, right? So it's that sort of, and access is supposed to be limited to the necessary tasks you need to perform your job. Here is the password policy. Folks are prohibited from writing down passwords and keeping them in plain view, disclosing passwords to another person other than the IT people or the security officer. And the privacy officer is the person that's in charge of HIPAA compliance in your specific department. Security officer is someone appointed by IT to ensure the privacy and security of really the electronic information databases, etc. And I believe our security officer is the director of IT, Diana Beltran. You should be recording passwords in a health initiative system or any other system of recording. Yeah, so I think the gist of this is to be smart about your passwords, which I have a hard time with. The modification and termination policy just says that IT and your privacy officer can modify, reduce, increase, terminate the level of access you have at any time for any reason and reserve the right to do that. And, you know, access can be terminated altogether on a case-by-case basis. So if you do something really bad, they're not going to let you access the child database anymore, but there'll probably be also be other repercussions for you that access to the child database will be the least of your work. You have a question? No? You? No? Me? Okay. Risk analysis and evaluation policy. So this is just that we have an annual risk assessment where we talk about all of the heads of the departments get together and talk about the work their staff does and how risk of vulnerability to the confidentiality of protected health information might change or is happening in different areas, and what steps we can take to protect against the risk of disclosure in those areas. And there is information here about specifically what we're charged with doing, so ensuring the confidentiality, integrity, and availability of all EPHI that we create, receive, maintain, or transmit, protect against reasonably anticipated threats or hazards to the security or integrity of that information, protect against any reasonably anticipated uses or disclosures of such information, and ensure compliance by you all. So we have an annual risk assessment with the HIPAA consultant. We take an inventory of all the protected health information and electronic protected health information and all components of the systems in which we keep it. We try to identify all the risks to that information, to quantify each risk, so to figure out how likely it is to occur and how harmful it will be if it did occur. And then we try to figure out a reasonable approach to minimizing the risk of that occurrence. We're all responsible for reporting new or changed risks. So basically, we need to have a conversation, you know, and we do this a lot at case review about HIPAA compliance off-site enrolling or on the helpline or in the different areas of practice, so that we can all be kind of up to date on what the risks are, so that we can plan for avoiding those risks. Okay, does anybody have questions about the analysis? All right, destruction policy. This is really simple. Destroy data that you no longer need to retain in the regular course of business. On the helpline, we've been in a paperless process for quite some time now. The case handlers, as of our move, are hopefully in a paperless process. But, you know, in terms of practically speaking, intake sheets, duplicative printout, client documents, once saved and shared, all of the things you don't necessarily need. You certainly don't need them hanging around, so they should be destroyed. And all our shredders are HIPAA compliant. They go this way and this way. And I'm, you know, the worst culprit of having lots of duplicative paper, but I've been better about shredding it every day, and you all should do that too.
So this client documents and signature folder, that's a physical folder or that's a digital folder?
Shah has a digital folder.
So my question is, because there was at some point there was conversation about how long we're supposed to keep records, because if the client were to come back to us and say, what did you do for us, and we have to keep record of what we've done, and so how does that? 7 years. 7 years. But so, not in paper form. Right, but this is not, they say that no longer needs to retain a regular course of business, client documents is shared in the shared folder, that's a digital folder, and we keep those things for 7 years in the digital folder. Right, so, and if you don't, I don't even know that it's necessary to date them in electronic form. In terms of the paper form that we archive a lot of our files, we dated them so that we can tell Iron Mountain when they can get rid of them, destroy them. But I'm not sure. I mean, I think
your department needs to decide, do you have a similar, and I believe you already do, a similar process where you keep client documents once they're received in a specific folder that's similar to ours with all of our client documents because they come in one stream through our eFax, or if it's that you're then saving them by name when you get them, because you guys don't necessarily get eFax documents like we do. Most of our cases start with that, so it's easier for us to kind of get them in the electronic system, and then never have to worry about the paper unless we physically want to be writing things down and looking at the paper. So does anybody have questions about shredding or other kind of destruction? There's then the whole piece with the privacy officers and them working with Francis to make sure that paper files are destroyed when relevant. And this is the 7 years. Okay, so this one is pretty interesting, social media and social networking policies. So the policies and procedures define social media and social networking, which I needed someone to do for me. And so this is all like web blogs and internet forums and social blogs and wikis, I don't even know what that is, those sorts of things. So, of course, use of social networks puts confidential financial and health information at risk, at even greater risk for breach of confidentiality or other harm. Health initiatives reserves the right to monitor and instruct staff and volunteers on the use of social media networking. They block social media sites on computers, and while staff and volunteers are on duty, and folks must not discuss operations, personnel, and client information while on or off duty when they're engaging in social media and networking. And there's, of course, a general prohibition from posting any content that's personally, individually identifiable health information. Luckily, we've never had to deal with this problem, but the HIPAA consultant at his training gives this really, I think, good example of a doctor who was on her Facebook talking about some, in a very small town or something, talking about
her patient,
ridiculousness of her patient, right? Right, but it was so it described her. It was right, and it was in a small town, and it had to be her, and it was like a very big to do. So be careful, and I should be saying this to myself when you're discussing that difficult client. Don't do it on Facebook. Okay, so we've talked a little bit about this. Supposedly all social media and social networking websites are blocked from health initiatives, computers, and mobile devices, and your BlackBerries. This doesn't, and they're, you're prohibited from using them during the workday. It doesn't apply to social media and networking off duty, except, of course, in regards to disclosing client information, which is always prohibited. And then there are certain members of our team that can access social media, right, that are authorized to do so, and it's part of their job to do so.
I was sure that you were going to. I thought you were going to curse. Yeah. On what? No, I'm just saying because it says that it's lost. If you want to record it, I don't think that.
Oh,
so okay.
We lost the connection for a minute, but I think we're okay now. This one? Good. Didn't it just say reconnected?
It's not pausing the voice recording, right? It's just pausing the recording.
I think the audio.
Yeah,
Good.
Yes, good.
Recognizing your voice, John.
Okay, so this is more of the same, but a little bit more of, you know, like a serious nature. You're not allowed to violate any state, local, or federal laws when using social media websites. In case you didn't know that, you're not allowed to transmit any material that is unlawful, threatening, profane, abusive, harassing, embarrassing, torturous, defamatory, obscene. So,
Like
you know,
libelous.
yeah, so, you know, hateful, right? So there's all these, this is kind of like, you know, use your brain, but these are all things that are actually in the policy that are, it's important. No impersonating any other person or entity. So yeah, it's pretty serious. So patent infringement, unsolicited or unauthorized advertising, no transmission of viruses, those sorts of things. And it says you should use a professional judgment when you're networking in terms of your job. All right, so this one is a good one because it talks about the physical transportation of protected health information, electronic protected health information, and work at home. And we have our mobile devices because we enroll in the community and we work in the community, and you know, potentially we even have physical documents that we need to protect. So it's good to you know, have a conversation about this. So no staff should any electronic or paper form of client protected health information prior authorization from the privacy officer. This is a typo, work monthly. You should be working on child cases during business hours at child location only, or if off-site or off-hours when specifically authorized. You're not supposed to work from home unless you're specifically authorized. And this is to avoid the high risk of harm of having protected health information, you know, having you access paper records or other protected health information while you're at home and you're not here for us to be watching what you're doing with it, really, or how careless you are with it. Now, I recognize that we all work in different kinds of forums, right? We're enrolling in the field and we're in the community, and so sometimes a client will give you a piece of paper that's relevant to their case that has protected health information on it, and what do you do with it if you're not supposed to take it home, if you're not supposed to walk around with it, right? So we have locked card container briefcases that folks should be taking with them if they think that they'll need them. And I know that East Harlem, there was a conversation in East Harlem about those because you have more likely you'll have paper records. And there's also the potential that we might need to work on an appeal from home because it's due on Monday and it's Friday and it's not done, right? And so those are things that we always work out amongst ourselves. You need permission for something like that. You shouldn't just be taking a client's paper file home or emailing to your personal email their electronic file and working on their appeal at home. That's not something you're supposed to do without my permission or the permission of other privacy officers. And you're responsible for maintaining the privacy and security of protected information that you transport, store, or access off-site, including, paper and electronic form. All equipment and media containing electronic protected health information must be signed out. So, and immediate supervisor is responsible for tracking the movement of that material. So anyone who has a laptop and a BlackBerry, that's all recorded, and you know what you have, and we collect it at the end of your, when you leave or when you're not, for example, enrolling in the community anymore, things like that. And all of this equipment must be encrypted. We have our laptops encrypted. Our BlackBerries have something different from encryption. And I'm just looking for this. I'm looking for the term that IT used because I was unfamiliar with it on what our BlackBerries have that's different from encryption, but of course I don't have it written down. Something PV, and it's the equivalent. Yep, it's equivalent of encryption, but it makes it so that encrypting the BlackBerry is like obsolete, but it doesn't have to happen. But so they are protected in that way, and of course your BlackBerries have to have passwords. Be password protected as your laptops do. So even though encrypted computers, laptops, iPads, BlackBerries must be password protected, no workforce member should write down their password and tape it to their BlackBerry. Was I guilty of that at any point? And have it plainly visible to any other person. Whether or not it's encrypted, it must be transported in a secure manner, like a locked container, for example. We determined that the bags we had for our laptops were so flimsy that putting a lock on it was like a funny joke, right? Because if anybody wanted the laptop, they could just rip the bag open and take the laptop. So now the laptops are encrypted, and hopefully that protects against that. But I do have the locker in the container the most out of anyone. But if you have occasion to use it, there's a box of them behind my door. You're all welcome to them at any time. You should immediately report any loss, theft, or compromise of PHI or electronic PHI taken or maintained outside of health initiatives to your privacy officer. You're not permitted to transport PHI home for work or any other purposes unless authorized. You will take your BlackBerries and, if necessary, because you're going to your next assignment, obviously been predetermined and authorized. Okay, does anybody have questions about work at home, transportation of protected health information? What else did we talk about? Social media networking. Certain bus do have scanners, right? Particularly you used to have a scanner. Yeah. So does the scanner store the information?
No, I think
import emails, and then we would have to carry around, let's say, like ID pushing documents or something.
Yeah, I mean, I think we do have scanners for that purpose.
Yeah, we work with scanners. You don't have one yet, but we need to carry around scanners, and that's why we No, we don't have as many physical documents. We scan it, goes directly onto our laptop.
Oh,
So it doesn't even have to go to our email.
I remember we talked about scanners just like off-site at the off-site location, so like if I was going to and we also going with real estate.
So I think some people do have that.
They do, I agree, for example, but also Reed has a lot of,
I don't think there's a lot of, is this case review yet?
No, it's the HIPAA policies and procedures training. It's going to be a couple minutes. Should we call you when case reviews come?
I'm only at the office today to go to case review.
Okay. Here's my head on maternity.
And we did telephones, sorry, did you get an answer to the scanner question? No.
So,
I don't have scanners. Go ahead.
So I remember the conversation, and the question for us was like, I think the concern was, for example, in a place like Harlem, which the office wasn't like as secured, we never got a straight answer, and obviously we didn't want to like keep carrying it around to make your bags heavier. And so
Some people do carry it around for sleep.
I know, but the question back then was, okay, if we get a scanner, can I leave it there, right? And so in places like Reed, yeah, that works because it's such a great in terms of like the office, and like it's hard for us to designate one place or one person, and we haven't been able to.
Yeah, that makes sense.
It's something that we can follow up on. And so.
But if people need that, identify themselves as needing a scanner that they can take around.
And we have available. Oh my God, a lot, yes.
Because there aren't offices in Harlem that long. There's like one guy, I forgot his name, but he has an office right next to that long. So that makes sense.
Okay.
I don't know. Anyway.
We can follow up on that, yeah, for sure.
Okay.
I just had a question because when I got my BlackBerry, there was no password, so I just have to figure out how to put a password on for it.
Yeah. And there's a button that says password protect. Yeah, definitely everyone's BlackBerry should be password protected, because if you lose that, people can just pull up anything that's on it. If it's not. Okay, so workstation use policy. Now, some of this stuff is going to get very, very almost ridiculous that it needs to be presented to you, but it's in the policy. So obviously, our computer workstations are vulnerable to environmental threats. They want to make sure that everybody's aware that, you know, the integrity of information is at stake. So they want you to limit eating and drinking at your station. They want you to take reasonable steps to ensure confidentiality of passwords at your station and not permit others to log on using your password. They don't want you to leave printers unattended. And we have, you know, in our kind of helpline policies and procedures, for example, we have administrative staff going around looking at the printers, looking at the fax machines, trying to make sure that things aren't hanging out where they shouldn't be. You should not, at your workstation, solicit outside business ventures, political campaigns, religious or charity causes. You shouldn't download or transport any data from databases, upload any software, and you must report potential threats to integrity of information at your workstation. The computers are programmed to generate screensavers when it receives no input, and then they're also locked. I feel like mine locked after 2 minutes. This says 10, but that's just to kind of ensure that the information isn't out there for anyone who walks by to see. And then this page just says all the things you're not allowed to do with your password.
I had a question on that.
Yeah. I'm just saying that you're not supposed to let other people log on your computer, but don't we have to go on other people's offices and use their computers? Like when?
Yeah, but you wouldn't do it with their login.
Can you go back to the other one?
Log on, sorry, I'm standing. I can't fix that one.
No, that one. This is the, no, not that one. I can find it. Don't worry. What is the there?
Another person to log onto the network with their password. So without prior approval.
I think that's something that IT and HR maybe have to coordinate with, because when we have new volunteers or staff members, they usually go a day without their own login information. So,
yeah,
you know, that's...
Yeah, and I think we've had this,
yeah.
you know, I think this been identified with a problem, how long it takes to onboard someone.
Yeah.
It's been an ongoing conversation for a number of months. It's just about, they can't, until the day you start and you fill out your paperwork, they can't process paperwork for you to get to IT and get a lot, even though they know who you are and that you're starting way before the day you start. So I think, so you're not supposed to hide your identity in order to modify anything in our databases or get into anyone else's login. And this is all stuff that's seriously obvious, but everybody needs to ensure and take reasonable steps that printers are not left unattended when they're printing confidential client or other information. This is relevant for us to have these big, huge monsters now. Just make sure if you're printing anything with PHI that you get up and you get your printout, only because we have people floating around, enrollments, clients, members of the general public, so pick up your information.
Would it be too annoying for people to have a code to release documents? Because if I sit there and I went over an hour, print 10 things and then pick them up at once, sometimes you can code it so that you walk over, you put in your pin.
I'm sure you can do that. I'm sure that was something that was probably, no, it was probably marketed to us, and if these machines, I'm sure, have the capability to do it. We've just probably disabled it because we thought it was annoying. But I'm sure we can do that. And then the privacy officer must develop a policy on hard copies, including identifying who may generate printouts, what should be done with the printouts, the purpose of those printouts, and this is maybe for you on the helpline. And then, of course, it's one of the administrative tasks that all of the administrative staff is tasked with is to be looking at the printing and fax machines for this information. Okay, the fax policy. I'm going to start to go fast because we're running out of time. We have the eFax system for new and existing client documents to limit potential public exposure to those documents. The use of conventional fax increases the risk of inadvertent disclosure, misdirection, or loss in transmission of documents with potential for breach. You should be limited if containing medical records only if no other means is available. You should check with your supervisor if you're not sure whether to fax something via conventional fax. And reasonable efforts should be made to ensure that the fax is sent to the right destination. Misdirection should be reported to the not the helpline supervisor unless you're a volunteer, but the privacy officer. There are admin checks, and admin folks are responsible to intercept faxes and distribute them properly, and they should not be left unattended. So they don't want you to use a conventional fax machine unless you really have no other means to get what you're trying to get that contains protected health information to where it needs to go. Sometimes we have a deadline for sending a fax. We have as long as we're documenting why we sent it via fax, because the deadline is today, it's fine. But check with your privacy.
So we're not able to send anything via eFax.
Right. We can.
No,
we can enable it. Mine has never worked.
It's not possible.
I couldn't do it before either.
Yeah, it's never, as far as I know, because I've asked for this many times to use a fax when we're outside a lot, and I have to wait until I'm near a fax machine. So I don't understand how. No, it's fine about why we are. I just don't understand. I have to use conventional fax with my other option.
Yeah, so that's fine, except for we can make this happen with that fax. So
I've been asking for it to happen for months.
Yeah. Okay.
Great.
Okay. Yeah. So this is the forum where we should be saying, it's great that that's the policy, but that's not how it happens, so that I can follow up with it. I actually thought that my inability to use eFax had to do with my technological
impairment.
Yes. Impairment. That was mean.
Hey, she taught me how to use this BlackBerry.
BlackBerry. I do know how to use my BlackBerry. Okay, so then this talks about the use of email versus fax and transmitting emails with secure documents if there's PHI in them, and which requires a password. I know a lot of us already do this. If we email, for example, Maria Ortiz Quesada at Medicaid Eligibility or TJ Weiner at NISO, we kind of tell the story, be identifying the client, and then attach a password-protected PDF with the client's identifying information. And that should be the general practice. We shouldn't just send an email with someone's Medicaid number or their health plan ID, etc.
Someone who knows how to do that, can they show those of us who don't know how to do it after it is? Okay.
Yeah.
All right.
I can do that too, so you know it's easy. And then information transmitted, even in this form, in the email form, must be limited to that which is necessary to meet the needs of the client or the requester's needs. So, you know, you don't need to give every extra protected health information or detail about the client. You just need to tell what's wrong with these fixes and why. Okay, misdirected faxes should be reported to the privacy officer, and there's a protocol here about what to do with misdirected faxes. You're supposed to call and tell them you got a fax, you shouldn't have gotten it, please shred it, and you need to record that somewhere that you did that.
Can you say somewhere?
Case notes? That's where you're recording everything, right?
Yeah.
All right, the email policy. So this is similar in that, you know, you're not supposed to use your CSS email for personal use, other business activity, solicitation, political campaigns, all the things that I keep saying about all the different technology that you use. The CSS emails are the property of CSS, which reserves the right to audit, delete, monitor, read the emails of staff and volunteers for quality assurance purposes, for administrative purposes, for auditing purposes. Emails with documents attached that have PHI should be password protected, and we shouldn't be forwarding client emails or emails that contain client information outside of health initiatives.
So what if we're emailing to the client, like I'm sending someone an appeal, a copy of their appeal, should I password protect that?
Mm-hmm.
Yeah.
It has, yeah.
Okay.
Well, can I ask another question related to that? Because
Sure.
that came up with the volunteers. So if you're sending the client, I don't know, copies of their bills on their account, I don't know why you would, or whatever related documents to that person, even if it contains their own protected health information, those are to be password protected.
Right, because the theory is that a hacker can get the protected health information. Not that there needs to be a release to disclose your information to yourself, but that you don't want anyone to intercept on the internet that client's information. You have to get it.
Okay.
What if they're sending it to you? Are we supposed to tell them to send password protected?
No, yeah, no, because they're not a covered entity under HIPAA. They're not bound to keep their own information confidential, right? It's us that's bound to keep their information confidential and protect its integrity.
And that's true internally as well. Like if I'm sending an email to Miriam and I'm like this, like that has to be password protected information, correct?
If it's about a client
Yeah,
specifically?
internally to our CSS email account.
But why would we ever send that?
No, like
Well,
you're
like-
forwarding an email, like the client.
So it's just, yeah, that kind of thing.
No, internally we can forward around email.
Okay.
It's outside of health initiative. Okay, so some of this is a bit repetitive. Emails contain this confidentiality statement. Should only have the minimum necessary to complete the communication. This is another one of these slides with, you know, no transmission of derogatory, inflammatory information about anyone's race, ethnicity, disability, religion, right? You can't be doing hostile stuff with CSS email. And we should all make reasonable efforts to redact or de-identify client information whenever it's appropriate. So if you're sending an example of a sentinel issue to a state employee, for example, and you don't expect them to fix your specific case, but you want to send them an example of your problem, you don't need to disclose PHI, just a general story, that sort of thing. That's how it's applicable to us. Shred duplicate emails, that sort of thing. All right, so the mobile device policy. If you have not signed a mobile device policy and you have a mobile device, you should. HR wants your signature file, and this is policy is very similar to the policy on the other kinds of technology, right? They don't want you using your mobile device to solicit business, to do anything obscene. They want to make sure you protect its integrity, that if it's lost or stolen or damaged, that you report it. They don't want you driving a car while you're on their BlackBerry, right? Because courts have held that employers may be responsible for accidents someone has if they're doing a work-related purpose on their phone when they shouldn't be. So there's all these really interesting things you never could think of in these policies. Your mobile devices must be secured with a password. We all have that on our BlackBerries and our laptops. You cannot engage in partisan political activity or other outside financial gain with your CSS-issued mobile devices. And upon termination of employment, all of these must be returned to CSS. They reserve the right not to pay you for your last couple of weeks of work until you do so. In violation of the mobile device policy could result in discipline.
And there's no porn.
No porn. No porn, bullying, harassment, discriminatory behavior. This was for all of the technology. All right, so the text messaging policy. They do not want you to be sending text messages with protected health information unless you absolutely have to. There's no other means to transmit something in an emergency. We normally are not using, sometimes we've used text messages during open enrollment to ask supervisors a question. I've gotten text messages on my BlackBerry that's a question from off-site, maybe when the email was down or something like that. But I don't know that this is a particular risk for us. Just everyone know that you shouldn't be text messaging protected health information or client information. And if you have to, it should be an emergency and you should get it approved by the privacy officer. And then they have a policy here around when you do send a text message, what it should say, and that it should be deleted after it's sent, so that if your BlackBerry is stolen, for example, that information can't be taken. All right, so the HIPAA sanction policy. Any member of health initiatives who believes that another member has breached the security or other HIPAA policies or otherwise violated client confidentiality must immediately report that breach to their supervisor or the privacy officer, and privacy officers are responsible for investigating those complaints and taking further steps to figure out what to do about it. Health initiatives may not retaliate against the complainant. So this defines what a breach is. It's the unauthorized acquisition, access, use, or disclosure of protected health information that compromises its security, privacy, or integrity. And here are some examples of possible breaches. So talking about clients outside with friends and families, writing your password on a Post-it and leaving it on your computer, leaving paper records on the subway, not in a locked container. The HIPAA consultant talks a lot about that, right? Violating a HIPAA policy, whether or not it results to harming a client. So this slide talks about progressive discipline and how there's a collective bargaining agreement. However, the sanction policy isn't progressive and it doesn't require lesser sanctions before terminating an employee. Basically, they're saying if you do something very egregious to violate a HIPAA policy, you can just be fired, irrespective of the collective bargaining agreement and progressive discipline that's available to you as a union member. There's two categories of misconduct that violate HIPAA sanction policies: inadvertent violations or infractions, and willful violations. Of course, inadvertent violations or infractions are things that are not necessarily done on purpose, and there are lesser, sanctions for those. And then willful violation is just what it says. It's when you're doing something on purpose or you're grossly negligent and it causes the breach of confidentiality, etc. So, I think the general message here is if you have any doubt or questions about HIPAA breach or handling protected health information or sensitive client information, ask your supervisor, check in with your colleague, find your privacy officer. The more we talk about it, the more we know in practice how things work and how we can comply with these policies or modify them to the extent that we can comply with them. All right, so this is about the security and the privacy officer's handling of willful breach. And it's for your information. I'm not going to go through it. But it just says that, these are also some types of willful breaches can be criminal offenses, and that CSS will cooperate with law enforcement regarding those. So if there's some sort of kind of massive sting where y'all are conspiring to steal client information on a mass basis, we're giving y'all up. I think that's what that's about. And then also if that issue violates professional ethics standards that you're subject to, we'll also be reporting you. And then this is the termination procedure, which is similar to the access and establishment procedure. The privacy officer, along with IT, takes a look at when you're leaving or if there's been a problem with access to data, and makes individual determinations about taking access to either the network or the databases away. And all staff and volunteers who are no longer working with health initiatives should be reported to IT and the privacy officer immediately so that access to these different the different data can be terminated immediately. And then this is some of the steps that IT takes to ensure that folks cannot access data after they're terminated or after they stop working for health initiatives. Okay, so this is pretty complicated, but clients are allowed by law to request a restriction on the use or disclosure of their protected health information. So when any of you get a request from a client to restrict the use or disclosure of their protected health information, it has to go to the privacy officer. The privacy officer makes a determination as to whether or not they're going to honor that request and needs to keep records of that for 6 years. So if somebody says to you, you're handling my mental health appeal, but I only want information that's in my record to be disclosed to the health plan for the purpose of this appeal, and I specifically do not want it to be disclosed to my mother, who will try to claim I'm incompetent, That's something that the privacy officer needs to be made aware of. It needs to be documented in their case notes, that sort of thing. And then there's a bunch of information about who can get information of a client based on the client's status as either an adult, so it's a power of attorney, someone who's a minor, and there's information in here about that. So if you have a client who's asking that certain information not be disclosed to certain entities or persons, it needs to be noted and run by the privacy officer for your department. This is the request for restriction form that clients can fill out in order, and this goes to the privacy officer in order to request a restriction. And then there is the HIPAA release of information policy. Clients have the right to access to information contained in their records. In order to use or disclose PHI, other than disclosures specifically authorized by law, we must obtain consent and provide the opportunity for someone to object. This is another policy where the privacy officer needs to be notified when the client or their representative requests information from their case record. We had this happen twice in the last, it hadn't happened for many years, and then it happened twice in the last 6 months. When the client or representative requests direct access to their record, or when the client or representative commences legal action. So if anybody asks you in relation to the handling of their case, or in the last 2 instances in relation to a totally separate matter where they thought that their case record from child was relevant, if anyone asks you for a copy of your record, you're to run it by the privacy officer who has the discretion to send the client what they're asking for, either any of the protected health information in their file, their case notes, which I'm loath to send because I feel like they're privileged, but occasionally I will send those. So that's something that you talk to the privacy officer about when folks ask you for that.
I have a quick question.
Yep.
If there's an Article 78 that we're not doing, is that an example of?
Yeah, that's a pretty good example. I had someone who, he was a trans client who we helped get top surgery maybe, and he wanted some information for his record about another action he had against an employer who he felt terminated him for discriminatory reasons. But that would be a perfect example.
If the client would like send me the final adverse, so I can put it with the Article 78, we should run that by the privacy officer.
Yeah, if a client wants any part of the record that we have, their record that we have, it should be noted, and the privacy officer should authorize it.
Okay.
And especially in relation to the actual case notes, that should be whether or not they get that, because some clients specifically ask for it. It should be run by the privacy officer. And then there are time frames around which you're supposed to be disclosing this information back to the client. So when someone asks you for this, you need to move on it. And then this slide speaks to the kind of authorization requirements you need depending upon the client. So, if their spouse is asking for information, if their power of attorney, if their mother, whatever, and then it speaks to the type of information you'll be disclosing. We don't have a particular form for this, but in putting together this presentation, I realized we need to have legal draft one, and so we'll send it around along with the restriction form. And these are the requirements of the form. And this is, again, the requirements on the authorization. And then notice of privacy practices. We have recently put notice of privacy practices up on the portal.
Not up yet, but it will be up this week.
Okay, so this will be up, and these are, just so you know, it's something that the clients are entitled to have notice of what our privacy practices are. They're going to be offered by volunteers. Volunteers are going to be referring people to our website where our notice of privacy practices will be posted. And if your clients are curious about it, this is what it looks like, and it's on the portal. I thought there was a slide on what the notice of privacy practice says, but it's omitted from here, so I can send the notice of privacy practices around for folks. So, what, in terms of like HIPAA in your daily practice and enrolling in the field and giving child advice in the field, is there anything that we should talk about in relation to these policies, or anything even, you know, this presentation wasn't very practical because it wasn't meant to be, but is there anything that is kind of on the tip of your tongue about open enrollment or about your daily practice that you want to discuss? So the follow-up items I have is regarding our client IDs from the database and e-fax to send docs. Is there anything else that people want me to follow up on? All feel, well, we cannot comply with that, or it would be onerous for us to comply with that, or we couldn't in our daily work.
How does any of this come into play when we have an adult client whose parent calls the helpline for them and says, Johnny, you know, got a claim denial, he needs help with his appeal? I mean, that person's an adult, the client, right? But the parent's the one doing the communication primarily. I mean, that.
Yeah. So there's an as you know so well, there's an authorized rep form for NISO, right?
For navigation, yeah.
Right. Right. But for the most part, for an issue like that on the helpline for a child case, I would say if they're an adult, they need to call us. Right? They need to be the contact. Mom can do the intake just like we do we could do the intake with mom just like we do with TA, and mom can send documents, but ultimately the person that needs to be in contact with us, unless there's a specific reason that they can't be or they've signed it over to mom, should be the actual client. Anyone else?
Would that be true if a young adult on the age of 6 playing along with the startup?
I mean, I think an argument can be made that mom has the access to information, but I think mom would have more access in terms of employer. Yeah, right. Yeah.
It just looks like there's an obvious conflict that is coming up.
Right, which we've had before where we couldn't access any information. You had a case like that.
Right.
But, I mean, I would prefer if it's a grown adult, you know, not a minor, that they're also at least giving some authorization to mom, right? Even if it's verbal and we're making a note in the case record, because we don't know necessarily what mom's motives are, right? We've had more than one case where the parent had the child insured, the adult child insured, that the parent and the adult child had no relationship, and the child was blocked from getting information, and, you know, potentially, who knows, the way the story goes was, kid is saying, dad is evil, he's not letting me do X, Y, Z, and I need this treatment. And so, it's, you know, it gets a little sticky. But you're right, it would be, in that instance where mom is a subscriber, it might be hard for us to otherwise access information without mom. Yeah. Right, there's a specific consent form there that's required, yep.
I feel like we talk about this on occasion about on-site or off-site, sorry, and we do a lot of work off-site, but in public spaces, and we don't have like office spaces to work in, and it doesn't really talk in any way about how how to navigate that, and I feel like we bring that, it gets brought up at case review on the regular.
Right.
It's something that's like,
yeah, so we're taking a couple of steps in light of those concerns. One is Francis, I hope you're going to where'd she go? Take this over while I'm gone. screensavers for the laptop so that when a person walking by can't decipher what's on the screen. And we've also ordered white noise makers.
Is that for enrollment here?
That's for enrollment off-site. I've asked that we get a bunch of them so that people that are in queues can use them, and volunteers have asked for them. Both the screensavers and the noise makers. So that enrollment clients that are walking by, volunteers can't see protected health information, as well as use by the professional staff. Sorry, Katie.
I guess I thought that, well, there is no policy around, like, so you're having a conversation with a client and, like, you're in a space where somebody overhears. Is that your responsibility? Like, how do you navigate that?
You're supposed to limit the risk of someone over here. So you're supposed to be cognizant of the fact that someone could overhear information that's sensitive and not use that information. So you don't have to say okay, sir, your Health Plus Medicaid Managed Care Plan number, blah, 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 blah. You can, you have to just kind of learn to talk around. I mean, the problem is even saying your insurance makes people aware that you're there counseling them about their insurance. It's not necessarily a HIPAA violation. But what
that's my question. It's like, where's the lines around HIPAA violations? Well, I just need to know, like, what would be a HIPAA violation in that respect, because we work in senior centers where we don't have spaces that are, like, closed off for us to meet with people. And
it wouldn't be a HIPAA violation simply that you're counseling someone in public.
Okay.
What the HIPAA violation is if there's this great risk of harm through exposure of protected health information, and in your daily practice you're not thinking about that risk of harm at all and trying to mitigate the harm or the exposure. So if you're in a senior center and you're saying, okay, well, we're going to only write down information that, if you need to get someone's Medicaid number, you write down your Medicaid number and pass it to me instead of you shouting your Medicaid number or your Social Security number or that sort of thing. And it's not easy. And no, these policies are not going to give guidance in writing on that, because that's not what that's not what they're meant to do.
Well, I think it's a mitigation question, right? You just try to limit the exposure.
Limit the risk.
Yeah.
Yeah.
But I bet you guys have really good ideas about how to mitigate. I mean, because you do it every day.
I know. I have really good ideas. Like, I have to be on the phone and talk to people and say, what's their Social Security number? And I have to be on the phone in a public space and repeat the Social Security number.
You also like this into the phone.
Yeah, and
I'm sure you do.
I think there's also, like, people yelling all over the place. So, like, there's this low.
Like our natural noise maker.
Yeah.
Seniors.
Yeah.
And it's good to know, like, that it's a mitigation. Say, like, we do our best and let that.
Right.
I
mean, what the feds want to know is that we've thought of this, that we're discussing it, that it's contemplated in our practice. We think about these things and how to comply with them.
Mm-hmm.
The other thing is, I know you guys recently got office space, but that it's hard to get folks to come out of their specific community to you.
Well, it's also use that office space for client meetings.
Because it's like we're the only ones there right now, and we don't want to bring people in and be by ourselves in this dark room. It's literally dark. So, when we get more people on
So
site,
this is exactly the type of exercise that we're required by the federal law to engage in. Right? We think about the risk of exposure of this information and what's reasonable in terms of implementing it. Is it reasonable to be, potentially subject to crimes and violence? Like, you don't want to be in physical harm to protect someone's protected health information, right? So it's all of this is stuff it's kind of like a balancing. And that's exactly why I was so upset about this presentation being so dry, because I wanted it to be more of a discussion, especially before I leave and before open enrollment, of HIPAA in our daily practice and how we can make sure to be complying to the best of our ability and anticipating risks and thinking about what reasonable remedies to those risks are or reasonable mitigating things that we could do. So I'm glad you brought that up. Yeah? No, anything?
Okay for you.
Anyone else have HIPAA questions before we move on?
You have to actually hit the top recording, stop the audio.
Oh, I'm sorry. I thought I